Folks are making their way in. Yes, and we are recording, and there is a link for a YouTube channel which Angela Franklin has created where you can see past trainings and follow along with what all of our colleagues across the state are doing for the Older Adult Behavioral Health Initiative. All right, folks, we got a lot of ground to cover, so I'm going to jump in there. Good morning and welcome to another offering of the 2023 Geriatric Competency Series offered to you in collaboration by the Older Adult Behavioral Health Initiative Specialist for the counties of Coos, Curry, Douglas, Jackson, and Josephine, Oregon. If you're not an Oregonian and you found your way here, kudos to you. We love that. Today's presentation will be an overview of public guardians for adults. We may touch somewhat on children, but our whole focus here for the initiative is older adults and adults with physical disabilities. Our panelists today are Sarah Bosma, Deputy Program Director of the Oregon Public Guardian and Conservators Program, Margaret Epple, Deputy Public Guardian for Jackson and Josephine counties, Elizabeth Saylor, Deputy Public Guardian for Coos, Curry, Douglas, and Lane. And we have Jackson County Court Visitor Vicki Bamman. We have a lot of expertise. You're going to want to hear more from them than from me, so let me move us on. A little bit of etiquette and housekeeping. Please mute your mics for right now. Yes, we will be taking questions along the way. Please put those in the chat. We will have some specific time for Q&A towards the end of our presentation. And if you have a burning question that must be answered in the moment, feel free to put it in the chat. You will receive 2 CEUs. They're no longer pending, they were approved. So there is a little bit of housekeeping you need to do for us. Those of you in the know that you need to complete an NASW certificate. And in order to receive a certificate of attendance, we need you to complete our Portland State University survey about today's training. We will make all materials available to you. You will have probably a couple of weeks before all of those details are figured out. So give us a little bit of grace, a little bit of time. Okay, if you are new to the Older Adult Behavioral Health Initiative, the initiative was started in 2015 to promote health, wellness, and to help us break down silos between agency partners and stakeholders who are in the world of older adults and adults with physical disability. And that means that we bring you free workforce development trainings, community education, and complex care consultations. Again, if you're interested in knowing more, you can either go to the website, oregonbhi.org, or reach out to the specialist of your county. And those folks are myself, Angela Jensen, and my partner extraordinaire, Angela Franklin, Douglas, Jami-Kwan Rudd, Jackson, Janine Greenwell, and Coos and Curry, Lulhati Anderson. All good people. And that brings us to the end of our introductions. And what I am going to do now is mess around with my screen so that I can bring up the slide deck and introduce our panelists for you. I'm sorry, on my screen, I don't get to see all of our presenters in a row. So I'm going to call on Sarah Bosma, our Deputy Program Director for the Oregon Public Guardians Program. Sarah, where are you?
I'm here. I really am.
Excellent. Sarah, I'm going to turn the mic over to you and you let me know how I need to advance slides for you. And I'm sorry, folks, this is the visual that we have for today. It ain't pretty, but you'll get the PowerPoint materials, like I say, in just a couple of weeks. Sarah?
Good morning, everybody. So as Angela said, I am Sarah Bosma. I am with the Oregon Public Guardian and Conservator program. I've worked with the program for just over 5 years now. I did public guardianship work up in Alaska for about almost 10 years before moving down here to kind of continue my career. And I started out in the field being the deputy public guardian for Central and Eastern Oregon back before we had more deputies than we have now. I am super pleased to be here along with several of my colleagues. Angela, I guess we should maybe just do quick introductions of all the different presenters, yeah? I see she's trying to unmute herself. Yeah.
I like that idea. Yes, please. If the panelists would please introduce themselves. We'll start with our OPG folks and chime in as you will. Take it away.
So Liz or Margaret, do you want to jump in real quick?
I'll go first.
Go ahead, Margaret.
I'm Margaret Epple. I am the Deputy Public Guardian for Jackson, Josephine, and Curry counties. And I've been working for Oregon Public Guardian just over 4 years. Prior to that, I worked for Aging and People with Disabilities for 13 years. And then I had 2 other jobs within the state of Oregon, DHS and the Oregon Employment Department. Go ahead, Liz.
My name is Liz Saylor. I am responsible for Lane County, Douglas County, and Coos County for the OPGC program. Originally, I am from North Dakota, and I moved to Oregon 2 years ago specifically for this position. I have a bachelor's degree in social work from North Dakota, and I am a nationally certified guardian, have been since 2017. My background includes direct support for individuals with intellectual and developmental disabilities, along with advocating for aging individuals and people with serious persistent mental illness. Personally, I follow a trauma-centered or trauma-informed person-centered approach to guardianship. And that would leave us with Vicki.
You know, I have to apologize. I haven't read the bio that I supplied. So I hope that my credentials match what I gave in my bio. I am a court visitor with Jackson County Circuit Court. I'm an independent contractor with the court. I've been a court visitor in Jackson County for 15 years approximately. Before that, I was the executive director of an ombudsman program in California, which was significantly different from Oregon. And I have a law degree, and I think that's pretty much it. I have a strong background in senior service, a number of boards of directors and volunteer work.
Thank you, Vicki. Erica, I know you're not really presenting today, but we have a new staff member. We'll be covering her new position in the slideshow. If you would just quickly introduce yourself, please, that'd be great.
Sure. I'm Erica. I am brand new Deputy Public Guardian in Jackson County, a grant-funded position that Sarah will talk about. My most recent experiences with APD in eligibility, case management, and APS.
So with that, we'll get started. We're going to do kind of a tag team approach with the OPG team. Margaret, you can jump in whenever you would like. If we forget something, you as well. Erica, we know we don't know everything. That is one of the greatest gifts of being a public guardian, is you are constantly learning and expanding your brain and like, wow, I didn't think that was even a possibility. Let's think that through. So first slide, please, Angela. Right. So way back in 2014, the Oregon Public Guardian program started with some pilot funding. And we didn't even really have staff at that point. But in 2015, we had our first employees hired. So we had one guardian conservator, which basically how our program runs is we have I like to call him the Oregon Public Guardian and Conservator, and that is Chris Rosen. He's our boss. And then he basically gives all of us our authority. So at that point, it wasn't Chris, but we had the Oregon Public Guardian and Conservator, two deputies serving the entire state, and an administrative specialist. So now we are fully staffed, but really we're never going to be fully staffed because there's always more work for us, quite frankly, with 13 employees. So we have the Oregon Public Guardian and Conservator, the Deputy Program Director, 9 deputies serving throughout the state, 1 screener, and we'll touch on his job role, who manages our entire referral wait list, except for the one that Margaret's managing anyway, and 1 office specialist. So we are technically fully staffed, at least for the next year and a half until we hit the next biennium, and maybe we'll get some more funding and then expand some more. But we are kind of working through our back wait list of our referrals. And some of you may be getting unpleasant phone calls of clearing people off of the wait list because we don't have a lot of capacity to take on new cases right now, except kind of in Southern Oregon. So we'll talk about that a little bit more. Essentially, all of our funding comes from the legislature. And if we don't get funding at the biennium through the legislature, then we don't grow very much. We had a special situation, which again, we'll cover in a second, this year, which gave us 1 new staff person, Erica, and we're super excited about that. But really, we need legislative support to grow our program. And I think that's about everything on that one. So next slide. Okay, so as I was alluding to, because our funding is so tied to the legislature and what happens there, and if they even meet and pass any, normal things during the session, there are some potential other sources to bring positions to our program. So we have tried, actually mostly in Southern Oregon at this point, to do some braided funding. This almost got off the ground, but then kind of didn't ultimately. But there are examples and basically roadmaps out there for funding a deputy public guardian position for a specific area through community support. So our recent example that didn't quite get off the ground was in Klamath and Lake counties, the Lake Health District, which included the community hospital and main medical provider in the area, along with the county of Lake and the county of Klamath and the city of Klamath Falls and Klamath Basin Behavioral Health, tried to kind of cobble together some funding to create 1 full-time position. That said, the Lake Health District was the biggest funder and they pulled out, so that one kind of fell apart. But this year, we were able to work with Asante. Most of you down in Southern Oregon know Asante pretty well. They're the main hospital down there. Asante has basically funded 1 full-time employee with our program, and that is Erica. So welcome, Erica, and thank you, Asante. Margaret has been working closely, and I guess really all of our programs, Liz as well, has been working closely with Asante for years, because Asante is really great about not discharging people without safe discharge plans. And lots of times a person needs a guardian to have a safe discharge plan. So we kind of use some of the language from that braided funding potential and turned it into the Asante position. And we were able to get the government to approve us to hire Erica. So she is pretty new. I think you've been here since July. No, that was 4 weeks. Okay. So just a month. She's just kind of getting some time under her belt. She's spending lots of time with Margaret, and it's fantastic to have her on board. We're super excited. And that position has 20 spots that are designated to it. That said, it's not just with Erica because people move all over the state here in Oregon. But basically, it has created some capacity in Southern Oregon for us to take on some new cases. So next slide, please. So as many of you know, Asante has locations in Medford, Ashland, and Grants Pass. They have identified that they have an exceptional need for guardians for patients in their care, which is kind of what led us to this road of getting this very specific position. And that's just a little bit more about, I guess I kind of sped ahead. I apologize for that, but Asante did fund Erica's position. Every deputy public guardian that works for our program has a capacity for 20 cases maximum. There's a little wiggle room in there. It can be a little more or a little less depending on your clients and how much time and energy they need. And if you have a volunteer, we also have a volunteer public guardian program. So if anybody wants to be a volunteer with our program, you can get in touch with me later. But generally around 20 people is what our caseloads are capped at. And then the Asante position will automatically renew, but our goal is to turn it into a regularly funded position through the legislature. So fingers crossed on that. We might be calling on some of our community partners down the road to kind of do some support for our program and the need for guardians really around our state, which we fully recognize is far more than our current staffing capacity has room for. So next slide, please, Angela. So this is just a kind of a basic map of who we are and where we cover. These are all of our regional deputies. So we have our 9 deputies around the state. So you'll see that Margaret and Erica kind of share that bottom quadrant there, 5 of Curry, Jackson, and Josephine counties. And then you'll see Liz up in number 3. So that is why she's here, because you are all one big Southern Oregon kind of team that's working together. And oh, sorry, I didn't hyperlink your email in there, Erica. And then I think our referrals and screening guy is left off of that list. Or it's not really left off of the list, but can you scroll down the page a little bit, Angela, and see if we can get Rob's information? Oops, no, that's okay. We have his information later in the slideshow very definitively. Oh, yay, there you go. Awesome, thank you. So our referrals and screening person is Rob Austin. And he is basically the person who manages the wait list for 95% of the state. And then Margaret is managing a very specific Asante wait list. If and when you were to ever want to put in a referral packet, we generally recommend that you reach out to Rob. He's going to need to ask you a million questions anyway. And so it's probably just a better use of your time to call him first before completing our packet. We do have an updated referral packet as of early September, which is a fillable PDF. And I can share that. We'll have Angela share that with the group after, once everything is sent out to everybody, you'll all get it. So do we have any questions so far or not really? No? Okay. All right, next slide, please. So we kind of talked about this a little bit, and part of the reason that the Older Adult Behavioral Health Initiative and OPG is such a wonderful collaboration is that we have a lot of crossover in our clients. So we serve actually probably more clients than the Older Adult Behavioral Health Initiative because our age span goes down to 18. So anyone that is an adult up to the end of their life, we can assist them. So we assist all adults with various disabilities who have an inability to receive and evaluate information, and which would impair their ability to make informed decisions for themselves. Sorry, I hope you don't hear my dog barking. The second thing on there is how we work with them is we are basically appointed by the Oregon court system once a person has been found to be incapacitated. There's a whole slide dedicated to incapacity. I think we talk about incapacity quite a lot, but that is our primary criteria for taking clients. And our referral and assessment process is very near and dear to our hearts. We take it very seriously because essentially when you, I think it's saying that I have a thumbs up, but I don't. We are deciding if we're going to take away somebody's rights when we pursue guardianship. So we take our referral and assessment process very, very seriously. We'll cover that more in depth a little bit later too. Our goal is to help our clients meet their basic health and safety needs. And we do our best to act on our clients' wishes. And we act on their behalf basically for what they want, unless it's going to cause them substantial harm. So all of this we'll cover more in depth a little bit later in the slideshow, but that's kind of the basics there. Next slide, please, Angela. Okay, so criteria. Oregon residents, 18 years and older. I think sometimes we do get people from hospitals that have wandered over state lines, quite frankly, that make it into our services, but it's because they don't have anywhere else to go and no family members or friends that are willing to help them get back to their state of residence. And so our office can become involved. One of our biggest criteria is that a person must be at imminent risk of harm due to their situation and incapacity that can only be addressed through guardianship. There's many ways that this can kind of show up, but generally we do not take people who are well placed in facilities. We take people that cannot figure out and don't have anybody to help them navigate the system. Part of that is if somebody is in a medical or mental health hospital and can't be safely discharged without guardian authorization, we can also be a part of that process. If they live in an in-home setting and want to stay there, but couldn't possibly manage all of the bits and pieces it would take to wrangle in-home care and get the supports and services they need to stay successfully in their home without, I can sort of see that question, but I'll let you pose that in a second here, Angela. So basically our office, if somebody is living in home, can help someone arrange services in theory to help them stay in their home successfully. One of our other criteria is that we are mandated to only work with people who don't have large amounts of resources or income. So typically our clients are all on Medicaid or will be on Medicaid once we finish our process. If someone has a lot of money or resources, we typically try to get them a private guardian because they can pay for those services. And our population is basically people who are on Medicaid. And the most important criteria, would say, beyond capacity would be having a reasonable and viable plan of how we're going to help this person once we're appointed as guardian. We can all acknowledge that people sometimes make bad decisions. Not a guardian can't solve all of those bad decisions and fix everything for a person if they're not really invested themselves. So what was that question, Angela? Should I just pull up my own questions?
Actually, I'm going to ask Jamie Kwan if she would help us with that. Otherwise, you're going to see my cursor all over these screens and it's going to be very annoying. So Jamie Kwan, can you chime in? with the
Absolutely.
question? Thank you.
So it says, are we going to get copies of these slides?
Yep.
And the answer is yes. And what about people who are not in facilities and have already lost their homes? For instance, to foreclosure, because a guardian wasn't in place already to help them keep their home.
We definitely deal with people out in the community. That's actually probably, I don't know, what would you guys say? 50-50% of like some people are coming out of the hospital or a hospital of some form or another. We'll just leave it at that. And other people are living in the community or living on the street. So we don't solely take people from the hospital. And even with the expansion down in Southern Oregon, there's still room to take people who aren't in the hospital. So yes.
Okay, and then we had one other question that says incapacity. Can you explain this further? Is it physical health, mental health? And then Liz was so kind to say we will get into this further. So we'll be answering that question in a moment. But at this point, those are all the questions that we have in our comment section right now.
Awesome. Thank you.
Absolutely.
Okay.
Feel free to move forward.
Yes. Next slide. Primary criteria, incapacity. I am going to close my meeting chat if I can, so that I can read a little bit better. And anybody from our program, feel free to jump in here. But basically, the main criteria that a person has to meet for our services is that they are unable to make informed decisions. So their brain, for whatever reason, it could be a developmental disability, it could be a mental health issue, it could be dementia, it could be a brain injury, but for whatever reason, their brain does not have the ability to take in information, kind of weigh the pros and cons of something and make an informed decision about, I think this would be the best thing for me to do. And at the same time, we have to acknowledge that there are people who do make informed decisions that are bad for them. If somebody, for example, can understand that they're using drugs and they might die using drugs, and they understand that they might want to have Narcan near them in case they need to be revived. A guardian probably isn't going to be able to help that person not use drugs. They are making an informed choice to use drugs and understand the potential ramification of using drugs. So that's a bad informed choice. That is not when a guardian would get involved. A guardian would get involved when someone has internal stimuli that is telling them, in the case of severe and persistent mental illness, that is telling them that if they take their medication for their heart, for their mental health, it's going to kill them because it's poisoned. That is somebody not really being able to reason through all of the things of making an informed decision. And sometimes it's even a matter of taking in the information and being able to express what a person wants. Sometimes our clients, we may get them when they are essentially catatonic or nonverbal, and they can't express what they want to do. And so we have the job of trying to figure out, how can we help? How can we figure out what they want? And we'll kind of get into the whole some more slides later down the line that will explain a little bit more about that. But basically, their incapacity puts them in a place where they are essentially putting themselves at risk every day because they aren't able to make informed choices. Again, drug addicts have a right to use drugs. We can appreciate that that's not a societal norm, but a guardian may not be able to fix that. And people do have a right to not take their mental health medications as long as they can still meet their basic needs of shelter. If they want to be in shelter, that's a whole other story. But food and making sure they have food and water and can access medical care as needed. There's a lot of people who are pretty darn crafty about getting their needs met when they are making societally inappropriate choices. It doesn't mean they're incapacitated. But if we think somebody doesn't realize that it's 20 below and they can't recognize to put on a coat, that's a different thing. So, and then capacity is fluid and subjective. This is really important to remember as well. Our services are provided based on need, and those whose capacity prevent them from meeting their survival needs to be prioritized. We also have probably a good amount of clients, and not necessarily, I think, in Southern Oregon, but clients who, and people who we have not accepted as clients, who will go to the hospital because they've been using drugs and they're temporarily incapacitated by their use of alcohol or drugs. But once their system is clear of the alcohol and drugs, they no longer have incapacity. That would not be an appropriate referral for our program either. Liz, do you have anything you want to add, or Margaret or Erica on that one?
Not quite yet. I just keep thinking I know they're going to get sick of me telling them about incapacity, so.
Okay, I'll stop talking then. We'll move to the next slide. Okay, so one of our other programs' big defining things is that we are kind of the last resort of the last resort. So our job, and this is a big thing if you're working with Rob, he is going to ask you, what have you tried instead of taking this person's rights away? Are there less restrictive alternatives to supporting this person in their decision-making rather than appointing a guardian, much less a state government employee? And a lot of people have lots of feelings, as we all know, about having a government employee work for them and or more or less make choices for them and run their lives. So, so for a lot of people, that isn't something they ever want to consider. But guardianship is very intrusive and restrictive. I mean, we do have the ability to make all kinds of decisions. We try to make decisions based on what the person would actually want, not what we want for them, but what the person would actually want. But anyway, back to the less restrictive alternatives. We try to find family members or friends that are willing to be supported decision makers or powers of attorney, use healthcare directives, declaration for mental health treatment. Let's see, what else? Durable power of attorney, that's for money. If somebody is having a hard time managing their money, and that is why they're having most of their problems, we always try to recommend getting some kind of financial assistance, be it a representative payee for their Social Security, or even maybe it's their neighbor because they've lost the ability to keep track of their bills. Maybe their neighbor sits down with them and helps them set up auto pay for all of their bills so their electricity doesn't keep getting shut off. If somebody has a lot of money, we can try to help them set up trusts or find them a private guardian or conservator. If somebody has recurrent episodic mental health issues, but they go a span of 2 or 3 years in between those recurrent episodic periods of incapacity, A civil commitment would be a less restrictive alternative to guardianship because a civil commitment expires. Guardianship does not expire. There's lots and lots of different ways that we try to encourage people to look at other avenues for help, to basically help them survive. Connecting them with community resources. When we have our high-risk team meetings, a lot of the time, which we host basically around the state and attend, we don't host all of them, but we really try to brainstorm out of the box. How can we help this person meet their basic needs? And Rob, if you are going to put in a referral, we'll spend a lot of time kind of talking about less restrictive alternatives in this way. And I put in here a link for lots of different less restrictive alternatives. And then when we send around this PowerPoint and the referral packet will go with it, there's a whole new page about less restrictive alternatives and things essentially that we will want you to have tried and or considered before making a referral to our office. Anybody want to jump in there and add anything from our team? No?
We just did have one question in the chat that doesn't really fit anywhere else, that someone wondered, what is the time commitment for being a volunteer with our program?
Well, Jana, so we basically ask, I think, for 8 to 10 hours a month. We have a whole training program. We're actually going to be doing a training, volunteer training, probably starting in late January, early February. We run training sessions with basically a cohort, so you'll all be getting the training at the same time. It's all virtually based. We try to connect you with, of course, a deputy that is near you to basically mentor you. And then that deputy chooses a case, a client that they think the person could work well with a volunteer. Not all of our clients are really suited to work with volunteers, so we're pretty selective. We don't give you the people that are constantly in turmoil, blowing up your phone. So it's 8 to 10 hours. I mean, that might be a bit of an overstatement, really, because our mandate is to visit people in person at least once a month. Our hope is that if we make a good connection between a volunteer and a client, that they actually might be able to spend more time together. And so it's relatively flexible on what works for a person and what works for the client, the client's needs. But I hope that answered. And maybe would somebody from my team find the volunteer public guardian page on our website and plunk it into the chat? Thank you, Liz. Ooh, okay, we love volunteers. Okay, what we are not. So thank you, Angela. We're not a quick fix. If you are calling us on a Wednesday and hoping that we're going to remedy a situation by Friday so the person is okay for the weekend, that is not probably going to happen. We're not really an emergent type of help. We're not case managers or direct service providers. We work for the state. So we work 40 hours a week. We do have an on-call person, but we have one on-call person for the entire state, which means we can't pick up people from the hospital in the middle of the night or go take somebody grocery shopping when they demand it. Our clients don't live with us. That's never, ever an expectation, actually. If you're interested in becoming a guardian, your clients do not have to live with you, and you do not assume their financial debt. So that's another story. But kind of our role as deputy public guardians with our program is to be decision makers and advocates for our clients. So we try to work with our clients, walk alongside them to figure out what they want and help them advocate for those decisions that they want pursued for them. So yeah, that can take many, many forms. we really realistically, and this is a hard one for people to kind of accept, we can't force someone to accept care, accept placement, or stop bad habits. The vast majority of facilities around Oregon are not secure, meaning if there's a client who really doesn't want to be there, they can walk away and walk down to the store and panhandle for some booze, and they're probably going to get it. We can't make people change their lifestyle if they're, how did you put it, Liz? If they have enough wherewithal to be able
If
to
they have the
sabotage.
capacity to sabotage your plan, they have more capacity than we can take from them.
Yes. So, and that I think has been kind of a growing pain that our program has been experiencing. We have a lot of clients that absolutely could benefit from a guardian, but if they won't accept our help and if they're actively sabotaging their plan every step along the way, we're just going to be chasing our tails when we could be helping somebody else that really is incapacitated and needs our help desperately to meet their basic care needs. So sum total of that is, yeah, we have people who are homeless, continue to use drugs and alcohol, refuse prescribed medications, and all the things that people hope that a guardian can fix. So on that cheery note, next slide.
Well, we'll give Sarah a little bit of a break. And this is kind of a little bit of the meat and potatoes of what Sarah was really starting to talk about. And I see that you are really curious about it. And so I want to talk a lot about capacity and the difference between guardianship and, well, I suppose really what guardianship can force and what guardianship can't do. To start off, guardianship is not a criminal matter. We are not a substitute for criminal proceedings. We're not punishment because somebody was naughty enough to need a guardian. We are not a form of incarceration or restoration. We're not going to be able to prevent people from continuing to use drugs. And we're not a mechanism for protecting society from dangerous people. What we are is an advocate for vulnerable adults. Guardianship is a civil matter, which means it is still a legal process, but it's entirely separate from the criminal one. We are protecting rights and interests of people who don't have the ability, like Sarah said, to take in information, mull it over, and make an informed decision. That means our focus is on enhancing and protecting the independence of that person and their self-reliance, and not just to get them to quit doing naughty stuff. Next slide, please. That takes us into, I pulled these directly from our Oregon revised statutes. So these are just definitions and I'm not going to read them, but capacity, incapacitated, and incompetent get used interchangeably a lot in our system and across the whole nation, right? But incapacitated, when we're talking about guardianship, is about decision-making. A defendant in a criminal process can be found incapacitated to stand or to aid in their defense, meaning they don't understand the process of their defense. They don't understand the criminal process. It has nothing to do with making safe choices about meeting their survival needs. And then on that same spectrum, a person who is guilty except for insanity may meet all of our criteria for needing a guardian, but again, we're not going to be the punishment for their bad behavior just because they don't have capacity to make good choices. Doesn't mean that we should be stepping in instead of the criminal justice system. Next slide. I wanted to talk more about the question we had about I'm going to scroll up and find it.
It was just the hospital placement.
Yes, if a public guardian makes the decision that someone needs hospitalization, can they insist that the person get placed? This is a huge misconception because yes, we make decisions for a person where if I break my leg, I can say, I need to go to the doctor and get it fixed. A person with mental illness might not even recognize that their leg is broken, and they might sit on the sidewalk forever. I can call an ambulance and insist that they take the person to the hospital, but if that person doesn't meet the hospital's acute criteria for meeting hospitalization, I can't force the hospital to take them. So that kind of goes along with Medicaid, long-term care, and community residential placement. So all of these different systems have their own legislative rules that they have to follow, criteria that a person needs to meet in order to be able to live there, funding that needs to be acquired by getting individuals to see certain doctors that maybe they haven't seen in their whole life. Maybe they are extremely traumatized by the healthcare system, and every time they walk into the hospital, they're going to assault somebody. In order for them to move into a care facility, I still need to be able to sign all the paperwork that says they've seen a doctor, they're going to get their meds. And so it's a whole process where we have to follow a lot of team effort. It can't just be the guardian swooping in and forcing it. Yeah, like Sarah said, we can do our best to try. We can do our best to be a support for the person to help them see that they need these things. We can supersede their decision if they're making a bad one. And we have, like Sarah said, a viable plan to make it happen. But if a person has capacity to sabotage this plan, it won't last. Like Sarah said, we can find a great placement, but if a person is addicted to alcohol and it's a block away from a bar, that perfect placement is still going to be a temptation for an individual, whether they've got a guardian or not. The problems that they start to cause because of their behavior is still going to put them at risk for losing placement, again, whether they've got a guardian. Any questions or anything to add for that?
I was just gonna say, I mean, we do advocate when we see that a client of ours is having a mental health issue, because we know our clients pretty darn well. And we will advocate with the hospital. Like, I understand that you think this doesn't meet your criteria. However, this is what we're seeing. So we really do try to advocate for our clients when we think they need an intervention. But yes, the hospital can ultimately say, no, thank you. So anyway, yeah.
And that's really just to emphasize that even when a guardian is established, it's still a team effort to protect a person and to support a person, because all of these pieces need to be working together. Sounds good. I think we can move on. This is going to just kind of get into some of the examples that I think people are really curious about. Reasons why a person might look like they should need a guardian, but we might, when we come in and do an assessment, decide that it may not be the most appropriate. People who are older adults who are victims of abuse, or people who have disabilities. A lot of lay people, and it can be scary to see somebody who is facing, let's say, financial abuse, where you recognize that they're giving all of their money away to their kids. A guardian can step in and put in certain restrictions to limit that person's access to their money, but we're not always going to be able to prevent a person from being in contact with that abusive person. We're not always going to be able to prevent a person from being abused. And ultimately, we still can't restrict the relationships that a person has with anybody without talking to the court about it first. Restricting access to relationships is probably the biggest form of restriction. And so every year when we're talking to the court about decisions that we make as guardians, we will have to say, we're no longer letting Mary talk to her daughter because she doesn't understand that she will lose her placement because of her daughter's behavior, those kinds of things. We can step in when a person's making a bad decision and they don't understand that it is going to risk their life or livelihood, but we can't always prevent everything. The next slide, please. So specifically, when we're looking at abusive situations, because obviously we do know that some would require a guardian to take them out of that abusive situation. We just can't assume that a person is incapacitated because they are victims. There are plenty of older adults who give away lots of their money and have every ability to make reasonable, rational decisions for themselves. They just make a bad choice. And it can't be the fallback for victims of domestic abuse, intimate partner violence, when it is taking away their right to self-determination. If there is a least restrictive alternative for an individual who is being abused, like Sarah mentioned before, perhaps a rep payee getting involved means this person's not giving away all of their money to every stranger who walks by. Maybe now they do get their bills paid and their needs met because there's a little bit more oversight, but it doesn't have to be guardianship. The next slide. Again, just really drilling this one in. Yes, we can look at situations like abuse, and we can look at situations like homelessness, addiction, mental illness, and say, does the person qualify for guardianship? Yes. But then when the referral comes to our agency, we really have to look at less restrictive alternatives, because we're taking away a person's right for self-determination and to be independent. The next one, Sarah, back to you.
Okay, so this will probably be a point of interest for many of you, because sometimes there are misconceptions about how our process goes. So this will just help kind of clarify things. So when you put in a referral, what the heck happens? How does it move from there? So basically, our process is that someone returns a referral packet to us. And again, we'll send that monster out here so you can see it and see what our criteria is and all that good sort of stuff. But someone, usually community partner, completes it, submits it, and then it will go on to our wait list. So in between those two steps, and again, why we recommend that people call our screener. And just so you know, the screener's information, the phone number on there and the fax number that are on the referral are all the screeners. The email that's on our referral is not the direct screener email. There's some technical issues there. But if you call Rob and talk to him, he'll walk you through all of that stuff. So when you submit that referral, or even before you submit that referral, you will talk to our screening and case assistant specialist. He will try to triage the case with you to figure out if there are less restrictive alternatives. Part of this process is, yes, finding less restrictive alternatives. And then also our wait list is dynamic. And so the most urgent case at that moment goes to the top of that list in that region. And in another minute, I have another slide that'll kind of clarify that point, or maybe just drive it home a little bit more. Typically, we do not immediately assign a referral for assessment, which is what we call our reports that we do. We do an in-depth report. We call them assessments. So usually when we get a referral, it goes onto a wait list, maybe for a week, maybe for a month, maybe for 6 months, maybe for a year. This is why we're not the quick fix, because our referral process also takes time. So sending in a referral packet does not create a place in line for guardianship, and it is definitely not a guarantee that we will accept the case and agree with the idea that the person needs a guardian. So again, the wait list is dynamic, and the most critical case gets assigned first, regardless of the date of submission. If things after you have submitted a referral start to go downhill, you notice that Dan's water has been turned off, and the same with his electricity. Those are important things for us to know and can alter where your person might be on a wait list. And those are things that can and should be relayed to our screener. And probably the best way to do that is email. If somebody was maybe in a situation where you could kind of see the writing on the wall that they were going to fail and be unable to meet their basic needs, and then they get a eviction notice and they've got 15 days to get out of their placement, that would be an important thing for us to know and may again alter their place on the wait list. So just keep in mind that it is all fluid, and it is very dynamic, and any changes that are negative or positive should be relayed to the screener. Sometimes, actually, one of the funny things about cleaning up our wait list has been that Rob has been talking to plenty of people who are like, oh no, we figured that out. We didn't have to take away their rights after all. So just, you know, there are ways around things sometimes. So next slide, please. Okay, so once the referral packet has been received, if the case meets our priority criteria, which is spelled out, do I have a slide on that? It's definitely spelled out in our referral packet, but if it meets our priority criteria, is the next most critical case in line, and the local deputy has the capacity to take on and manage the case long-term, then it gets assigned to be written up as a referral process assessment. So there's a whole thing to happen. But once it's been assigned, because it's risen to the top of the list and all those first criteria are met, then a deputy typically has 30 days to complete the assessment. This means that we are contacting all the people that we know of or can find in a person's life, their mental health providers, their PCP, their neighbors, their friends, their family members. If they've had extensive contact with hospitals, we'll be trying to contact those folks and get records. One way that the process of the referral or the assessment can be sped up is if we actually get copies of records directly at the time of assessment, rather than us having to wait for the medical provider to get the records back to us, because that can sometimes take months, unfortunately. So including as much information and documentation as possible can increase the speed of our assessment process. That said, because the case may be sitting on a wait list for a little bit, it's probably a good idea to wait to send all of those records until Rob calls you and says, hey, I think I'm going to assign this case. What's going on right now? Can you get me all the current records? So, and we only really look at a 2-year window kind of maximum. I mean, we can look at a person's whole life, but in terms of reviewing records, typically we only are looking at the last 2 years. So once that assessment report is all typed up, it goes to our boss for a decision on, can our office help this person? Are they incapacitated? Do we have a viable plan? Or is this person somebody that doesn't meet our criteria, or we don't think we're going to be able to help? And then our boss is ultimately the guy who says, yes or no, we're taking that case, or we're not. Angela, can you advance the slide? I'm hoping.
While you do that, I was just gonna say there was a great question in the chat
yeah.
asking if there were any barriers to privacy during the assessment. And I think that's awesome because in our revised statute, we actually do have the authority to get any information that we need to make a determination for guardianship because it recognizes that the person's life is probably at stake. So that is an awesome question.
Yeah, absolutely. And we typically, when we're requesting records, certainly we can share that statute with everybody, but when we're requesting records from providers, we share that with them very liberally to say like, hey, we received this referral because somebody is worried this person, right, can't survive on their own. Please share these records with us. And here's the statute. And that includes financial records too, also. Although the Social Security Administration won't play with us until we have official records on file. Anyway, that's other story. So if our boss says, yeah, I think we can help this person and we should take them into our guardianship roles, then the court process begins. So you have the 30 days. It's usually like if it's an emergency case, it can be 7 days or 30 days to write up the assessment. Then you have the court process. We are completely ineffective until we have court orders in hand to actually do anything for the client. So the petitioning process begins. Actually in Southern Oregon, there's typically a lawyer down there who is very well versed at creating petitions for clients. In lots of cases, we do it ourselves. And so we write up the petition for the person, submit it to the court. Orders or our petition and letters for guardianship, temporary guardianship, can be issued within a few days if it's an emergent case. Typically, it takes usually longer than that, depending on the situation of the person and how dire their needs are and what we need to get accomplished in order to keep them as safe and healthy as possible. If we get that emergency temporary guardianship right away, then it's usually only good for 30 days. Sometimes we do extensions of those 30 days. Sometimes if we're not sure, honestly, if we're going to be able to help somebody, we'll do multiple temporary guardianships to see if we can actually make a positive difference or if they're going to sabotage and we're not going to be effective. And then in some cases, we skip the emergency temporary guardianship because maybe they're already safely housed and so their basic needs are being met, but we know they're going to need a guardian long term. So then we submit to the court. That can be a longer process, sometimes a month, sometimes longer, really depends on the court. Typically, well, not typically, there is a period that the client, the proposed protected person, can object to having the guardian appointed. That can very definitely draw out the process because sometimes the court will want to have a hearing and that requires all the parties. And so it can, so the moral of this slide is that the process can take 3 days or it could take 3 months. Or sometimes judges also have really funny ideas about how things should go and they can really hinder our authority. Anyway, or court visitors, not you, Vicki, but we have some different court visitors around the state that say funny things. And then we're like, so you don't think we should be able to place that person? Huh? Okay, that's very fascinating. Anyway, different courts operate very differently around the state. And all of that is completely beyond our control. So we just kind of have to sit and wait, and we all do the hurry up and wait to a certain extent in this process. And now Vicki's going to explain the role of a court visitor. Are you, I think you're muted still, Vicki.
There. So, hi. Taking some notes while I was listening to all your presentations, and thank you. I'll try to get back to them, but one of the things that first I'll say a lot of what I'm going to be speaking to is structured around Oregon statute. So with any apologies to anyone who's joined us from outside the state of Oregon, I will refer you to Oregon's statute. One of the first things that comes to my mind is that with my background with the Ombudsman program, our mission was to protect the rights and the dignity of people living in long-term care facilities. And nowhere in the guardianship conservatorship statute is the word dignity used. And I like to sort of remind that to everybody too. We try, and I'm speaking for the guardians as well as myself, we try very hard to protect dignity wherever and whenever possible. Not always possible, but we do consider it a valuable component to our work. So there's that word. If you go to the slides, you'll see under the category of appointment of visitors, there's a citation that I will direct you to. You can find in the Oregon statute a detailed description. But beyond that, under the category of protecting the rights of incapacitated persons, the WHO is threefold actually. The visitor, and the WHO is the visitor, and then also the what we refer to as the respondent. The respondent is the proposed protected person. So you'll hear me use the term respondent, but basically that's the same as client. So, and then beyond that, the proposed guardian is, of course, the third WHO. And most often, in the cases that we see, the petitioner is also the proposed guardian. But in your case, the petitioner may be the state of Oregon, and the proposed guardian may be a specific individual. Going back to visitors, if I can go back to that, in Jackson County, we have 4 court visitors. We're all trained individuals. Coincidentally, we're all very experienced and seasoned. I've been court visiting for about 15 years, and I would say over that 15-year period, probably average about 3 to 4 cases a month. And so that's a pretty substantial number of cases that I've had experience with. Another visitor has been with the program even longer. Well, two have been with the program longer than I have, but one started originally as a volunteer before there was such a thing as a paid court visitor. Those other 2 individuals are both social workers. And then the fourth court visitor in Jackson County also has a law degree. Until a year ago, we had a retired judge who was a court visitor. Throughout the state, there are different systems. And in some cases, court visitors are independent contractors, like we are in Jackson County, where in my case, I work out of my home. In other districts, and they're not, I don't think they're all by, well, I guess they are all by county. They do have some volunteer court visitors, and they do have some paid court staff who act as court visitors. I think there's one county where the district attorney is the court visitor. So it's varying. For the most part, we are, and you're probably interested in this, but we're paid $400 per case. That's the average throughout the state of Oregon. In a few cases, the court visitor is paid an hourly rate, and often there's a cap on that total amount. I think one jurisdiction pays $5.50 a case, so it varies. So one of the questions that I frequently get from social workers is, how do you get to be a court visitor? So that's why I threw in the payment part, just so you know. And let's see, we are appointed by the court in Jackson County, and it's not uniform throughout the state. The court has a list of people who are qualified, the 4 of us, and it's a rotation list. So as cases come in, we are appointed to a case based on rotation. In some counties, the attorneys are able to select their court visitors. So it varies from one county to the next. Then the other who is the protected person, the respondent. And in my personal experience, I see about 75% of the people I see are seniors with dementia. And that dementia is usually Alzheimer's or alcohol related or Lewy body. And then maybe 15% are adults with schizoaffective bipolar diagnoses, or maybe a serious accident, some kind of a brain injury from a motorcycle or a car accident. And then about 10% of the people I see are IDD, youngsters reaching majority. So their parents are petitioning to be appointed legal guardians for their youngsters. And of the seniors that I see, maybe 20% are indigent, and the remainder are low to moderate income, and a smaller minority are in Jackson County are wealthy. And then of the bipolar schizophrenic, most often they are homeless, they're out on the street, and their family members are in a tailspin trying to figure out a way to help them and protect them. So, and I'll give you a little anecdote very quickly. I had about 6 months ago, a youngster who was in a very extreme bipolar situation, and he was in jail. And his family was very, very distressed and wanted to get him moved to behavioral health, moved from the jail to behavioral health. So I went to interview him at the jail, and while I was there, 2 sheriffs came out to the lobby to escort me to this young man who was in solitary confinement. And when they came out, they explained the reason he was in solitary was because he refused to wear clothes. So, are you willing to interview him? Okay. And so they took me back to solitary, anticipating to see this naked young man. Fortunately, the door had only a very small window at eye level. So if indeed he was naked, I wouldn't have seen anything anyway. But they did tell me that when they explained to him that I was there, that he covered himself up. So I knew in advance that he was at least that cognizant. And indeed, I had difficulty communicating because the little window was not easy to communicate through. And I said, your dad wants to be appointed legal guardian for you. And he said, great. So it was one of those easy cases. Fortunately, that was all I needed to hear. I could have left right at that point, and especially because the communication was difficult. But at any rate, that's a little bit unusual, but nevertheless, those are the kinds of cases that we sometimes get. The other kind of case that we'll see is a pro se, and that's when someone is representing themselves and they do not have an attorney. And so the court visitor is not allowed to give any legal advice. So indeed, what I can only do, and they stumble around and they try to fill out all the forms themselves. And there is one firm in Medford, excuse me, I moved from California. There's one firm in Medford that will help people fill out forms. They don't do a great job, but nevertheless, I will try to help those pro se people by pointing them in the right direction and giving them resources online. So that's how we see the pro se cases. The court visitors receive payment directly from attorneys. The attorneys have received payment from their client, or we receive payment directly from the client if they're pro se. So what do? Well, we investigate. And I guess the easiest way is to just describe the sequence of that investigation. And basically it starts with an interview by telephone. And my first call is, I'm trying to turn on a timer so that I can not talk too terribly long. My first effort is a phone interview with the petitioner. And most often the petitioner is also the proposed guardian. So, you know, I try to get the lay of the land, and that telephone interview generally runs about an hour. I ask them, what is going on right now that that you felt the need to file a petition for guardianship for this particular individual? So they sort of give me some history, and at the same time, they'll tell me what the immediate needs are. And from that petitioner proposed guardian, I will ask for a list of contacts. And those will be people that I will be contacting by telephone. And I'll be asking two questions. Do they agree that a guardianship is appropriate? One. And two, if they do, do they agree that John Doe is the right person to be appointed guardian? I really like to speak with professionals, and especially social workers. But I encourage that individual to put together a list of names and phone numbers of family members, professionals, medical personnel, friends, neighbors, clergy, et cetera, et cetera. And if it's a petition that's also for a conservatorship, then I need to know the financial contacts, if there are financial planners, where the individual banks, et cetera, that kind of information. So I try to speak with all of those individuals. And then my very next step is to meet with the proposed guardian and the respondent together. I like to see a little interaction between the two. And then I give each person an opportunity to speak with me in private. I also encourage the respondent to give me a list of their contacts, of people that they may want me to talk with. And I try to contact all of those individuals as well with the same questions. And then based on that collection of all that information, then I write my report and make my recommendation, explaining to everyone that I speak with that I am a neutral third party. And the easiest way to describe that is that I'm the eyes and the ears of the judge, that the judge can't come and visit in person, so the judge sends me. So based on the collection of that information, and I always explain that I need to speak with as many people in order to collect enough information to be able to make an informed recommendation to the judge. So if there is an objection from either the respondent or from any of the individuals that I interview, I must indicate that in my report, so that even if that person doesn't have the wherewithal to go ahead and file an objection directly with the court, I can then let the court know that yes, there is an objection, and a little bit of why or who or what it's about. Based on that objection, then a court hearing will be held. Now, I've received the petition for the guardianship directly from the court. And the petition that I receive indicates that it's either that it is and or a temporary or a permanent guardianship, a temporary and permanent, or a temporary or permanent. Temporary is a euphemism for emergency. And in Jackson County, the judges treat a temporary as an emergency. And most often they will go ahead and approve the temporary emergency when it's received. So most often that guardianship is legally in place almost on the day when it's filed. And that 15-day, no wait, that 5-day, I have two statutory constraints. And for a temporary guardianship, I have only 5 calendar days in which to make my recommendation to the court. And for an indefinite / permanent guardianship, I have 15 calendar days in which to make my report. So then, based on my report, if indeed there's been an objection, then a hearing will be held. And if a hearing is held, then I'm called to testify. If there are no objections, and if I recommend the appointment, then there'll be no need for a hearing. The judge will go ahead and approve the guardianship. And at the end of the temporary guardianship, then the judge will go ahead. And again, if there have been no objections, the judge will go ahead and approve the permanent guardianship. I prefer indefinite guardianship. So the benefits of the judgment. Let's see what I have here. We're there to protect the rights of the respondent, of the individual. And that's not always easy. Sometimes they're fighting us, and I don't want a guardian. I don't need a guardian. And at the same time, they're acting in dangerous behavior. So we have to weigh that, and we have to look at the fact that individuals, no matter how they're living, have a certain amount, a right to use poor judgment. And indeed, we need to weigh how to protect their safety and well-being, at the same time, protect their dignity and their poor judgment. So that's one of the important factors that the visitors take into consideration. And weighing, and I will go back to the dark ages when I was in law school and looking at capacity and competency. And those were always challenging, trying to figure out the when and the where. And guardianship attorneys have difficulty with that as well. So that's a challenge that we're always trying to be very sensitive to. So we look at the suitability of the appointment of the guardian. We consider their perspective, their biases, their fears, and we have to weigh whether or not that person is capable of being objective and trying to be compassionate and not judgmental. So those are considerations, serious considerations. Yeah, we make an informed recommendation to the judge, and we hope that we're being able to build trust because we identify and repeat that we are neutral. It's very rare that we'll receive information after a judge has approved a guardianship. I'd say in 15 years, I've had that happen fewer than half a dozen times. My client base is not necessarily the same, or the majority of my client base is not necessarily the same as the majority of your client base. There was one year, one very remarkable year, when I had 75 cases that came to me from legal aid. And that was unique and hasn't happened since and wouldn't happen again. There was one court visitor who refused to take any pro bono cases. So all the pro bono cases were coming to me, and legal aid knew that I was receptive to any case that would be pointed in my direction. I happen to love the work that I do. And so they were very eager to send cases to me as well. So there was one year where I did have cases that might have gone to a public guardian had we had enough public guardians. But indeed, that's not the case anymore. I think I've sort of run my limit. there's some questions or?
A good
Hello.
time for folks to chime in. All good stuff. I learned some factoids that I didn't know before, especially the time frames. Do we have anything in the chat, Jemmy Kwan?
We have a couple of things, but they have been, Liz is on it. Just love Liz. Liz has answered most of the questions, so.
I do see, I have a couple of notes here.
I'm scrolling back through to see where Liz has not answered. So, let's see, we've got one from, could you clarify this slide? If the public guardian makes the decision that someone needs hospitalization, can they then insist the person get placed? And then there was an answer, we can and do try. So that was one and answered. Then we had one, so are you on 24/7 for emergencies? Sarah answered. We also have one from Megan that says, are there any private barriers during the period of time? And Liz answered, great question. It is written in our ORs. The next one was, and that's it. So that there were,
I
thank
do have a
you.
note here.
So
And
Vicki
one-
would
I'm
like
sorry.
to add.
One more just popped up. Sorry, I do apologize. It says, Robert says, I am assuming CVs have the same access to records that guardians have in order to make their determination. Is this accurate? And I do apologize for interrupting you. That just popped up.
Yes, indeed. We may be able to help you with that. We have access to medical records. And one of the court visitors always automatically gets all the medical records, and she attaches them to her court visitor report. I have not done that. However, I can do that, and that might help you all move a little more quickly. If you run into barriers getting medical records, if we are able to attach them to the court visitors report, and if you have access to the court visitors report. Now, we can, and in my case, I almost always do make my court visitors report confidential because of HIPAA. And so I'm not sure what access you have to the court visitors report, but through your attorney, you should have that access. That might help facilitate your access to medical records on a, on a speedier basis. So that's one thing, and that was in my notes that I might be able to do that. The other thing is that while we don't force someone to receive a certain level of care necessarily, clients can be released from a hospital to a locked facility or to the state hospital. And that's based on a hearing that generally is in the hospital that is outside the purview of the court visitor. And I don't know the details. You probably know more about that than I do.
Yeah, the main problem actually with secure residential treatment facilities right now is the lack of actual beds available to place people there. But oftentimes, I mean, not oftentimes, we have some clients that really do need that level of structure and support. So thank you so much, Vicki, for sharing all of that information. And I'm sure it's really kind of county by county if we're allowed to see court visitor reports in OGIN. But if we know that you're the court visitor, we may just be reaching out to you as well, just to brainstorm with you about our clients and all that good sort of stuff. So I appreciate your offer to kind of work together on stuff. Thank you.
Well, and your attorney would have access to those reports.
Yes, that's true. So excellent. Next slide, Angela. So after the court makes its decision, this is kind of when the real work begins. So sometimes people will talk to us when we're in that kind of interim period, depending on the situation of the client and the case and where they currently are. But really, we're not very effective until we get some signed letters of guardianship and limited judgment back from the court system. It can be temporary. That gives us a certain amount of authority. But for example, the Social Security Administration and banks really don't like to talk to us or give us any information until we're appointed long-term. So once a court has decided that our office is going to be a person's guardian, we wait for those orders essentially, and then hit the ground running to try to serve our clients' needs. Some kind of finer points about guardianship is they generally last through a person's lifetime, which is why they are so darn restrictive. Their guardianships are generally not removed unless a person regains capacity. That has happened. We have released a couple of cases from our care just because they have the ability to make their own informed decisions. Again, if the court decides another person would be better as a guardian for a person, or if a less restrictive alternative of a guardian comes up, like maybe a brother, sister, son, daughter decides, hey, I would actually like to be guardian now. We would always be in support of our guardianship ending in terms of that. If the guardian resigns or passes away, the person actually usually is who passes away. And sometimes the guardian also may resign or pass away. And then there can be a successor guardianship. But just because, I mean, I think we try to, depending on the person, you try to keep a guardian in place, even if the guardian passes away, because usually that person needs help. We've definitely received a couple of cases from like grandparents that were the court appointed guardians for their grandkids. So next slide, please. So there's a lot of things that guardians can do and not do. We'll have it a whole nother slide, but we can't authorize sterilization. We cannot use a person's money to pay ourselves. We actually don't get paid. We get paid by the state. So our clients don't pay us. We definitely cannot remove a person's free will. Guardians can request from the court that they be paid for services, or if a person is living with them, to be paid for room and board. Although that's generally kind of frowned upon, but that happens a lot with, adults with intellectual disabilities living with their parents. One of the other things that we do as guardians is we have to notify the court of all placements. Our office actually takes placements very seriously because that's probably one of the biggest determining factors in our client's success. So we also basically say, hey, we have to come and inspect your place and talk to you to see if you can meet our client's needs. And then we accept the placement, and then we have to submit notice to the court. And all guardians, not just public guardians, are required to notify the court of a change of address of their person. So,
Sarah, we had a couple people ask in the chat, what happens if a person would move across state lines? And I don't know if you want to just give a little answer to that one.
Yeah, so, and I'm trying to see what you guys said here. So yeah, okay, so when people move across state lines, typically our office will not stay involved as our guardian. Our office is for residents of Oregon, Oregonians. So we would try to facilitate a transfer to someone else. If that, like, we do have clients who have goals to move out of state, and in the process of doing that, they're going to build their independence and hopefully not need a guardian any longer. So we would help that person with the process to dismiss the Oregon guardianship and not pursue another one. There are some uniform guardianship protection acts that can allow you to kind of transfer guardianships between state lines. But really, our office tries to keep our people in the state of Oregon. I think one of the things that Vicki is probably acutely aware of, and our office is acutely aware of, is like Medicaid and services in Idaho and California are vastly different than how Oregon works. So we don't really want to be operating in systems that we don't know about. If a person has a private guardian or a family guardian and moves out of state, my understanding is that typically you should try to get court orders in the state that the person is residing. And that said, when I was a public guardian up in Alaska, I had people all over the United States and was kind of able to do my job just fine with those court orders. So it kind of depends on who you're working with, the person that you're working with, and the people that are serving them, if things can continue to go. But our office typically tries to keep our clients in the state. So we don't really facilitate placements outside of the state, I guess is a good way to say it, unless there's really some extreme need that can't be met here. But we really try to facilitate placements within the state. So that typically doesn't happen. I hope that answers the question. And then the Veterans Administration, we have some good contacts at the Veterans Administration, and they can also be extremely officious in getting information out of. But I think once we're appointed, I don't think they're usually very willing to play ball until we have court orders. But once we're appointed, then we can work pretty well with them. It's not an easy process to work with the Veterans Administration. If someone is moving to Oregon and seeking a public guardian, is that what the question is? Or is somebody with a private guardian that wants to move the
I
person?
think Becca has a specific case in mind that she is probably going to reach out to us and staff.
Gotcha. Okay. Yeah, so we do, Melissa, actually get a fair amount of clients who land in the hospitals in Oregon that we become their guardian. I mean, not a fair amount. A handful of clients have come to Oregon by way of California or Idaho, and have stayed here because our office has been appointed. So yes, I'm gonna go back to the slides for a second because I think we're gonna have time to answer questions once we get through all of these, and I want to get through our slideshow and then allow for extra questions. So under guardianship, a client still has a whole slew of rights. They can be restricted by court order, so it's very important for guardians and the people working with people under guardianship to read through the court orders to make sure that there aren't any additional restrictions. But generally a person can still go to work, vote, pursue education, whatever that means for them. They can marry, they can divorce. We don't typically get involved with marriages and divorces unless we will not tell somebody to not get married or to not get divorced. We try to support the person with their choice. They have a right to have children and engage in adult relationships. We've had parents of adults with developmental disabilities call us and say, I don't like my daughter's boyfriend. Can I restrict that? No, you can't. Unless it's really like dangerous for that person. And Liz kind of talked about that, having to explain to the court why you're trying to restrict relationships. But for the most part, people are allowed to have adult sexual relationships regardless of guardianship status. Our clients can pursue driver's licenses. They can have friends and associate with whoever they choose as long as it's not an extreme risk. They have a right to their own records, and they have a right to object to the guardianship or retain a lawyer to fight the guardianship. Again, we don't necessarily facilitate if we feel like our client needs a guardian. We're not going to say, here's this lawyer, go talk to them for free. But if they can figure it out on their own, good for them. You know, they have every right to say, I don't like this guardianship, I don't want it. But the fact of the matter is, if somebody really doesn't need a guardian, chances are we're going to try to get them off of our program anyway, and be helping them with that process. So next slide, please. And Liz is going to jump in here.
I just want to take a little bit of time kind of again to go over how we do make decisions for the individuals that we support. Our program is made up specifically of individuals who are nationally certified guardians. So we all follow the National Guardianship Association Code of Ethics. And I posted a link because it is really a handbook of how to make a decision for another person. Our first and foremost choice is always going to be to find the preference of the protected person, either their past preferences, what they want now, and to try to accommodate that as much as we can, unless we know that there's going to be substantial harm. So a person who has spent their entire life without stable housing may not ever feel comfortable being in stable housing. And so we might try to reasonably accommodate that. The next one we would follow is substituted judgment. So what would that person choose for themselves if they were able to? And then the last is the best interest standard. And the reason it's the last is because what I believe to be somebody's best interest might not be, it might be wrong. What I believe might not be what they believe to be in their best interest. And so that's why really we do try to find the preference that that person would have made in if they had the capacity to make that decision on their own. As guardians, we need to recognize that we have limitations in knowledge. I will be the first person to say that every client I have tells me that they could be my guardian and how young I am. And so I recognize that is a barrier to my knowledge. I then, like I said before, rely on a team of experts in the community. We work with treatment teams and families. We work with the court systems to make decisions for another person. I never pretend to be an expert on that person because I've not lived their life. I am going to be the person that supports them in making decisions to the best of their ability. And when those decisions are going to cause significant harm, that's where I believe it is my role to step in. One example that I'll give is medication management, right? Because when you're looking at a mental illness, I have a gigantic book of all kinds of different diagnoses and all kinds of different medications that might help and might not. And a lot of those have side effects. And when an individual goes and talks to their doctor and says, I hate being on these medications, and their doctor says, well, it's good for you, I'm going to be the person that asks why they hate being on them, because maybe nobody's ever asked, what do these medications make you feel like? Well, they make me really sweaty and they make me really fat and I get really mad all the time and I'm tired. That's a conversation a neurotypical person could have with their doctor, and a person who has a guardian is probably just going to need some support. So, you know, for the point, I guess, that I'm trying to make is that I'm not an expert in really anything except supporting people in finding the experts that they need. Next slide, please. As a guardian, we have an obligation to protect the personal and pecuniary, that means financial, interests of the person first and foremost. It is not to their families, it's not to service providers. And I get to be the bearer of bad news when providers are expecting their bills to be paid immediately as soon as guardianship is established, and that's not going to happen. Like we kind of talked about, banks and Social Security, they don't care about our guardianship paperwork, and it's going to be a long process to get any of that stuff taken care of. And so the first priority is always going to be making sure the person has food, shelter, medical care, and then we're going to worry about all the rest of it. That's why we do thoroughly investigate the preferences of the person, because I am going to get their buy-in to a plan they choose a lot easier than buying into a plan that I'm forcing them into. That's kind of why when I talk about trauma-informed care and person-centered planning, a person who has been or perceived to be abused by the criminal justice system and the medical system and anybody who we might see as trying to help them, it's going to take me some time to build up their trust, to build a rapport with them, to investigate the decisions that they would make if they hadn't had all of those experiences already. And then I need to also understand my limitations in authority and guardianship. Like Sarah mentioned, there's a whole list of things that we're not going to restrict from people. A lot of doctors will come up and say, well, this person is obviously really sick and they should be a code 3, and you need to be the one to tell them that and change their code status. But I like to remind people that as an adult, as neurotypical adults, we want to be able to have that conversation with doctors and be able to choose that for ourselves. If I'm talking to a person and when they get sick, they're going to fight going to the hospital. Yep, sure. I'm going to use that communication as a sign that they would rather stay in a place that they're comfortable, stay in a place that they're familiar, and probably pass away. But if I have a person who gets sick, recognizes that they're sick, and is demanding to go to the hospital, I'm not going to be the one that says, you can't, because you're probably going to die. So those are why all of the decisions that we make as guardians have to go through a whole planning process. We work with the person because ultimately we are working with people's lives and not my own. We are also custody of the person, which means that we are responsible for their place of abode, which Sarah talked about. We need to make sure that the place is going to take care of them and meet their needs. If a person, I have an individual who is living safely and warmly in a residential care facility, but he really believes that he would be able to manage if he went back to his hometown and was homeless again. And while I can respect his decisions, I also have to understand that those would not be meeting his needs. And so then we do supersede his decisions on that one. Management of the estate is really just the money part. And like Sarah kind of talked about at the beginning, most of our referrals and clients don't have money. They don't have estates to manage or plan for. But in the private guardianship world, that is probably a responsibility. We would need to make sure that if they owned a house, that was upkept, or that it was sold responsibly, that their money was taken care of and managed, not mishandled. And so, yeah, like Sarah said, our program doesn't do that so much because of the nature of our clients. But you may see clients in your communities with guardianships who do have financial authority.
And so just to clarify one little piece, so our office delegates all of our financial authority basically to a representative payee for our clients. So our office doesn't typically hold on to our clients' money, which is actually a beautiful thing. I really appreciate it. You don't like fighting. It's no fun to fight with people about their money. And then if somebody were to have more than $10,000 in resources or assets, that person would require a conservatorship, which is a whole separate legal proceeding. But we don't do those either, typically, because we don't have those clients with assets and resources. So I think that's kind of it. Next slide. I think we've been kind of following along a little bit. So somebody asked a question about filing paperwork and if it has to be in the county. It does typically have to be in the county where the person has been residing. Sometimes the courts get a little persnickety with us when a person has been in a hospital and it's not really their place where they've been living. But in the case of somebody who fumbled their way into Oregon from California, we definitely file it in, Jackson County if they're, in the hospital in Jackson County. So anyway, what other questions are there? How do you become a public guardian? You wait for an opening in our program when we're hiring. I would keep your eyes peeled, maybe like next July to September. Hopefully we'll have some positions available. There are also ways to become a private guardian. And there's a organization in Oregon called the Guardian Conservator Association of Oregon, GCAOregon.org, that can help you become a private guardian. But really, our office only has the positions available that we have funding for. And it's just a matter of kind of waiting for a position to open up and then applying and doing all the things about getting hired for a new job.
Wow. As we're starting to wrap up, I know that there's going to be some more questions that bubble up from folks. Who should they direct their questions to? Should it go straight to you, Sarah? And then you can kind of farm it out to the team as needed?
Sure.
Because not everybody who sends in questions, they may not all be from Southern Oregon counties. So
Right.
Somebody has to take lead. I vote you.
Thanks, Angela. You always
bet.
have faith in me.
Always, my friend. And I think with 4 minutes left, we want to be respectful of time. I think this is a good place to stop and wrap things up. I want to thank all of our panelists and those of you that are in it for the long haul. And I'm going to turn the mic over to my esteemed colleague, Janine Greenwell from Jackson County.
And thank you all for an excellent presentation today. We really appreciate it. You as participants will receive an email from Lou Hottie Anderson with the slides, the referral packet, and the NASW evaluation for CEUs. Portland State University evaluates the Oregon Older Adult Behavioral Health Initiative, and you will receive an email from PSU. Once you complete PSU's evaluation, you will receive a certificate of attendance. This presentation concludes our series under geriatric competencies for this year, but please provide some feedback on the PSU evaluation. That's important to us to improve our trainings and gives us ideas for next year's geriatric competencies. Thank you so much.
Thanks everybody for joining us. We'll share all of our information, and it was great to meet everybody.